Steve Cohen, Tennessee.
Thank you, Mr. Chairman. I'm going to take up a little bit where Ms. Sutton left off. Mr. Wainstein, you've testified that one reason we shouldn't worry about Americans being spied on as a result of surveillance without a warrant that is directed at persons overseas under the PAA is minimalization procedures to handle the acquisition, dissemination, and retention of incidentally collected U.S. person information. Is that true?
Yeah, I think that's a very important part of the protections, both under the PAA and under other collections as well.
So people shouldn't have to worry because if they're spied on incidentally, because you'll minimize what's done with the information. Is that right?
Well, I guess the way I'd frame it is that minimization procedures were adopted. You know, they go back before 1978, but in the context of general signal intelligence overseas, they were adopted. They're applied rigorously. They're trained on in the intelligence community so that if you're legitimately targeting somebody overseas, that person calls somebody in the United States, there's U.S. person information gleaned from that U.S. person information is handled carefully so that the U.S. person's name and identifying information is stripped out unless that information is necessary to understand the foreign intelligence value of that information. So it protects U.S. person information from being sort of disseminated and used in an inappropriate way. So I think it is a very important protection. And it's one that has existed for a long time, and the PAA does not change it.
And you can assure us that these names, if they're picked up, aren't ever released in any way?
Well, I think the minimization procedures, some are classified, some are not classified. But essentially what they do is, this is laid out in unclassified form, and we can provide copies to you, the ones that are unclassified, but it says if you get this information that it has to be retained in a certain way, it can only be disseminated under certain conditions, you can only disseminate the U.S. person identifying information if you need that information for the consumer of the intelligence to understand the foreign intelligence value of that information. So it's a very sort of careful, sort of sequenced handling of that information so that, yeah, there are situations where the name Ken Wainstein might come up in a surveillance and that name will end up in a report, intelligence report, because it's important that Ken Wainstein's name be included in that report to make sense of it.
Well, Mr. Wainstein, let me ask you this. Newsweek, and you're probably familiar with this, in 2006, reported that in a 2-year period, the NSA supplied the names of some 10,000 American citizens to interested officials and other agencies that the NSA had obtained, minimized information, and they kept it in their files. Are you familiar with that?
I'm not familiar with that specific report. I'm sorry, sir.
Do we have can we put a copy of that Newsweek report in the record, Mr. Chairman?
Without objection, so ordered.
Thank you. The issue is that if you get the information, we've got to rely. There's no warrants involved here. That's right.
Well, there are minimization procedures that do apply to FISA orders. Yeah.
But there's no warrant if your target is foreign.
Right.
There's no warrant in that context. Not now.
Mr. McConnell, let me ask you this. The police, as you well know, are you an attorney?
I am not, no.
Don't need to be an attorney to know this. American citizen. Yesterday was Constitution Day, so we all need to remember the Constitution, the Fourth Amendment, and all those things. The police can't come into your house without a warrant, look around, copy files, take things, whatever, and claim there was no violation of your rights just because they threw everything away, or they restricted its use on their own initiative after they looked into your home and, without a warrant, violated the Constitution and went back to the station. Wouldn't you agree that minimalization can't cure the damage done to privacy when the communications are intercepted in the first place?
I just refer back to how I opened up my statement at the beginning. The fault of 9/11 is we had someone in this country calling a terrorist that we didn't collect the information on, terrorist overseas. So the issue is protecting the country, and when our target is foreign and it's incidental coverage, you have to think about who's the target and where's the target.
Who was you say that was in your original testimony? That was somebody in Florida, right?
San Diego, I believe it was.
San Diego. Who did they call? You say a terrorist. Did we know that person was a terrorist at the time?
Overseas, yes, sir.
We knew it. And we didn't do anything at all?
For whatever reason, we didn't connect the dots for that. Now, let me set up the situation how it might happen today. Sleeper in this country we don't know about. Some sleeper that's been here for years. And Al-Qaeda, some member that we know about, calls in. The reason for the way it's set up is if they activate that sleeper, we'd have some way of knowing. We might prevent a 9/11 or a sarin gas attack in a subway or whatever it might be. In the course of international communications, first of all, we would only be conducting surveillance if it has a foreign intelligence target interest, and we just don't indiscriminately look at the world. So we'd have some reason to look at it. So if it's incidental, has nothing to do with intelligence, that's what minimization is. You just take it out of the database.
Well, I want to thank you for your service to the country, and particularly, I believe you served when President Clinton was president. Is that correct?
I did, yes, sir.
Appreciate your service, sir.
Mr. Chairman, may I just respond a little bit to that last question? Very briefly. The question is one that's been posed before, and I believe Congressman Lundgren addressed this earlier, which is minimization sufficient, or should we have to go get a court order when we have a valid surveillance against one target and that person talks to another person, a person in the United States? Should we get some sort of court order to allow us to get that communication? And you analogized the criminal context just now. And actually, the same situation applies in the criminal context when we're getting wiretaps under Title III in law enforcement cases. If you get a wiretap authority against me, go to court, get an order to intercept me, I have a phone call with Ben Powell. Law enforcement is allowed to collect that surveillance, collect that communication without going to the court to get a separate order to authorize the listening and the communication of Ben Powell. Rather, that communication is just minimized because he's a United States person. He might well be innocent. So the same thing, different minimization procedures, but minimization is used on the criminal side as well as on the foreign intelligence side.
Thank you for your comment, Mr. Chairman. You weren't around during President Clinton's time?
Yes, I was.
You were? Well, then I was going to thank you in spite of the fact that maybe you weren't, but I still thank you for your service, too. I don't want to discriminate.
I was a prosecutor using Title III.
Thank you.